Well, thank you for joining us for today's webinar, To Trust or Not to Trust. This webinar is part of an ongoing partnership with the UAB National Alumni Society and UAB Office of Planned Giving. I'm Greg Berry, Assistant Director in the UAB Office of Alumni Affairs. Just a quick note, since we're virtual, don't be surprised if something may be out of place or technical issues pop up. If you have any audio or video issues, click the Reconnect button at the top of your screen. That will get you back to the webinar quickly. Today, we will find out how to best utilize trusts in our estate planning. Before we introduce our guests, I would like to ask a quick question. Where are you in your estate planning process? The poll options include your estate is set, and we're just seeking a few tidbits to see if you should change anything. Your estate is coming along, but you want to fill in a few holes. Maybe you're just starting out and need a lot of guidance. Or perhaps you thought the title was a misprint and was expecting Hamlet or Shakespeare instead of a trust webinar. I'm going to go ahead and keep the poll up just for a few moments so you can submit your answer. At the end of today's presentation, we will have time to get to your questions. So submit those in the chat box. And the poll is working very well today. Looks like most of you are just starting out. Over 50%, 53% are just starting out. We can go ahead and slide the poll off, but 24 say their estate is set, 20% say it's coming along, 52% say they're just starting out, and wait, what? This is Shakespeare, received 5% of the vote. So with no further ado, I would like to introduce Kimberly Kopic, Director of Development for the UAB Office of Planned Giving, to introduce today's guest. Kimberly.
Thank you, Greg. As Greg said, my name is Kimberly Kopic. I'm the Senior Director of Planned Giving here at UAB, and it is my very great pleasure this afternoon to introduce our speaker, Jennifer McInerney. Jennifer is an attorney at Carney Dye, where she specializes in small business law and estate planning with an emphasis on special needs advocacy. She received her JD from Indiana University and is currently working on her LL.M in tax from Washington University, St. Louis. Jenny is a two-time graduate from UAB. She obtained her undergrad in history and political science and her master's in history. While at UAB, she was a member of the cross-country and track team and was the editor of the Vulcan Historical Review. Go Blazers, indeed. Jenny is married to her husband, Carrie, and together they have 3 children, ages 20, 18, and 4. She is on the board of directors for Susan G. Komen, Jefferson County Intellectual and Developmental Disabilities Authority, Special Siblings, Shelby Humane Society, and the Birmingham Zoo Development Committee. Jenny, we are so excited to have you with us this afternoon. And without any further ado, I'll turn it over to you.
Thank you so much. It's a pleasure to be here. I want to thank everyone for spending your lunch hour listening to my presentation. I greatly appreciate your time and consideration. I'm going to kind of walk through the presentation today, and I know there's an option for you to submit questions, so feel free to submit your questions as we move through the presentation. But just to kind of get started, today's presentation will focus a little bit on trusts, and we're going to start out with some basic trust information. What is a trust? Then we'll move into how you can use a trust for minor children being children under the ages of 19. 19 is the age of majority in the state of Alabama. Then we'll move into irrevocable and revocable trusts. And those questions we'll look at are, do my parents need a trust? And do I need a trust? We'll move into special needs trusts and how you can use a special needs trust to protect a loved one with a disability. And then we'll look at other trusts that you can consider, like marital trusts, pet trusts, gun trusts, charitable trusts, life insurance, managing property in multiple states, and using it for lifetime management of funds for a loved one. So a little bit about our firm. We are Carney Dye Law Firm. We specialize in wills and trusts, special needs planning, estate administration, trust administration, guardianships, conservatorships, and business planning. There are 3 attorneys in our office, Jack Carney, Shannon Dye, and myself. Okay, so to get started, we're going to start off today with just the basics. What is a trust? You've probably heard about trust before, but you might not really know what it means. A trust is simply a legal document. It's a legal agreement between a settlor and a trustee. And we'll go through some of those definitions in a minute. It is a legal entity that is created by a legal document. It holds title to property or assets for the benefit of a third party, the beneficiary. It will provide protection of those assets. It ensures the assets are distributed according to the stated wishes of the grantor, and it ensures that the assets and the property are prudently invested. Next, just a little information about the different types of trusts. Generally, they can be lumped into two categories. Inter vivos simply means during the grantor's life. Once the grantor signs the inter vivos trust document, the trust is considered its own separate entity and it's active and it can be funded immediately. And a testamentary trust is a trust that is a part of your last will and testament. And that trust will only kind of spring to life when that person dies. So if you are a couple, a husband and wife, and you have your will set up with a trust in that will, your trust will only spring to life once the second of you pass away. And we'll talk a little bit about that in a minute when we talk more about setting up family trusts for minor children. Okay, just some basic parts of a trust. You'll hear me talk about a grantor or settlor. That is the individual who's creating the trust and the person who their assets are going into that trust. The trustee, who I always say is the most important person in any estate plan that you name or you appoint. The trustee is an individual or an entity, because it can be a bank, charged with administering the terms of the trust. They protect and preserve the assets, and they manage and control the distributions pursuant to the terms of the trust. The beneficiary is the person who has a present or future interest in the trust, and the corpus of the trust is the property that is transferred into the trust. So before we kind of dive into the world of trusts, we're going to start off with just some common myths. These are actual things that we hear a lot in our office when we recommend a family or an individual utilize a trust. They'll say, "Oh, no, I don't need an estate. I don't need a trust with my estate plan. That's only for the ultra wealthy. That's for the super wealthy people. That's not for me. I fall in just a middle class family income. We definitely don't need a trust." That's not true. Many of our clients utilize trusts for a variety of reasons, many of what we'll discuss today, and it has nothing to do with how much money your estate has. All right, the second common myth is that once a trust is established, access to resources will be denied. That's also false. The trustee who you appoint for that trust will be tasked with properly managing the trust. So while access may be restricted, it will not be completely denied. The third common myth that we often hear is that trusts are too expensive to maintain. This is also false. Many trusts that are established as part of an estate plan the trustees are often family members or friends who don't take fees for actually being the trustee of that trust. Now, professional trustees do charge a fee for their work and for managing that trust, but those fees must be reasonable and are not typically excessive, and they are disclosed up front. Okay, so the most common trust that we utilize here at our office would be trust for minor children. And you may think, hey, I don't need a trust for my minor children. They're 10. Nothing will likely happen to me now. The truth is I always tell families when they come to our office is that when you do your estate plan, you're planning for now. You're planning for a family disaster now, not for 5 or 10 or 20 years down the road. When things change in 5, 10, or 20 years, you can come back to us and we can update your documents. But when you set up your estate plan, especially if you have minor children, it's very important to establish that family trust. And the reason that's important is because a minor in the state of Alabama cannot inherit money in an estate. It would have to be set up in a conservatorship with a court. Those can be very costly processes, and they don't have as many options for investment, so your assets won't produce as high of a return as they could somewhere else. There are just many drawbacks to actually having a conservatorship versus having a trust set up for your minor children. So the way that we typically structure these types of situations where a couple comes in with minor children is we will set up a standard family trust, which will protect the assets of that minor child, but will still allow flexibility for that trustee to distribute funds necessary for the beneficiary's needs. The trust can be designed to terminate at a specific age, as opposed to a conservatorship, which terminates at the age of 19, and that individual inherits the money at that point. Trust can be terminated at any age or event. You could say, I want 1/3 to be distributed to my child at the age of 25, 1/3 at age 30 or 35 or 40. You can determine that once your child graduates from college, they can receive a distribution. There's just so much more flexibility with a family trust for minor children. You can design it in the way that meets your wishes. So I always say, doing an estate plan for your minor children in the event that something tragic happens to you and your spouse, this trust will allow your children and these decisions to be made as if you were still here. The other benefit of having a trust for a minor child is that the beneficiary, at their death, the remaining assets could pass on to one or more remaining beneficiaries. So if you have multiple children and one individual passes away, that one child passes away, the remainder can be distributed to the other remaining children. And typically those trusts for minor children are testamentary trusts, so they are only going to spring to life once you pass away. So, do you need a trust for your children? If you have minor children, I would say yes, you do. You can always change your estate plan once your children reach the age of 19 or whatever age you've determined that they can receive these distributions. You can always update it and make those changes. But as I mentioned earlier, conservatorships are more restrictive, they're more costly, and they do terminate at age 19. I have a daughter who's 19. And I can assure you, at even 20, I don't want her receiving her inheritance if something were to happen with us. I would want that to be staggered, where she would inherit portions at a time. And I would want to ensure that somebody that I trust would be managing those distributions, and someone that I've trusted and I've appointed is handling the investment and kind of direction for my children financially for their future. These types of trusts can also deal with unique situations, such as a beneficiary not ready to receive money. So we're going to talk a little bit about that in a minute, but this could also be structured in a way to deal with addiction. Trusts are a great way. We see a lot of families come in who are really struggling with whether or not to leave an inheritance to a child or family member who has addiction or alcoholism, and they're fearful of leaving an estate to them that individual will then use those funds to further their addiction. And one great thing that you can do with the trust is to build in buffers for that type of situation. We could build in that the trust can pay for treatment if the individual wants to go in for rehab. It could build in protections that the individual has to pass drug tests in order to receive distributions. There's just so much more flexibility and restrictions that you can put on a trust to deal with these unique situations that most people are simply not aware that trusts can do. Okay, so aside from yourself needing a trust, many of us at this point in life, I'll age myself a little. I'm in my 40s. And as my parents get older, and as I work with clients my age or older, a lot of them come to us and say, you know, do my parents need a trust? The answer is maybe. You know, trusts are really beneficial when planning for your parents, for dealing for, say, Medicaid planning. They're a great way to avoid probate. Now, we typically don't recommend a living trust for most of our clients, simply because probate is not as costly and problematic as maybe it used to be. Probate's pretty simple in the state of Alabama. Living trusts are much more common in Florida. But if you or your parents own property in multiple states, we do recommend a trust to kind of manage those properties so that at your passing, a probate estate is not having to be opened in every single state where you own that property. Recently had a client whose father was put on hospice, and he owned property in 5 states. And we were able to move all of those properties into his trust prior to his passing, so that estate only had to be opened in 1 state versus 5 states. Standalone trust can be a really wonderful tool for asset planning. As I said a minute ago, for avoiding probate. There is also great if you are anticipating incapacity. If your parents have been diagnosed with dementia and you have concerns about their ability to manage money, or they're being more easily influenced by others to take advantage of them, trusts are a really great tool for that. If you are appointed as the trustee, you can help oversee what money is being used, where the money is going. You're the one approving whether distributions are being made. And it's also increased privacy. For, you know, trust is never going to be filed in probate court versus a will, which is filed. So there's just a little more privacy with trusts. And as I mentioned a minute ago, trusts are also a viable tool in anticipation of needing Medicaid. One of the things we do here at our office is Medicaid applications and Medicaid planning. And so if you have parents who are looking at needing to go into a skilled facility or a nursing home of some kind with increased care, you may be looking at needing to do a Medicaid application. And in doing so, you will know that Medicaid has a 60-month look-back period where you're going to have to gather their assets. And one way that we can use a trust in that scenario is to pool their money into a trust for their benefit, which then could make them Medicaid eligible sooner rather than using those funds to pay for care in the interim. Okay, so you may have heard of revocable or irrevocable trusts. You know, you may want a revocable trust. The revocable trust is the trust that would hold property in multiple states. It's one where you can revoke it. You can terminate it at any time. You can make changes to it. Irrevocable simply means you cannot revoke it. Once you set up that trust, it's irrevocable. You can't terminate it. But irrevocable trusts are really good for those Medicaid planning situations that I just spoke about, because they're such good tools for managing someone else's financial affairs. You want to make sure they can't get access to it in the event of undue influence and you know, take the money out of the trust or transfer property out of the trust. Another really popular trust that we do a lot of here in our office is a special needs trust. And you may think, you know, I don't need a special needs trust. Well, special needs trusts are very, very useful tools for a beneficiary who is permanently disabled. I meet with lots of parents who have disabled children. One of my daughters has a disability, And we have a special needs trust for her already established. And the reason that a special needs trust is so important is, for example, my daughter has autism, and her disability makes it very difficult for her to manage money, to understand and appreciate money. And while she can do basic day-to-day finances, some of those bigger financial decisions are going to be a struggle for her down the road. No matter how much therapy we've given or provided to her, no matter how many, financial literacy classes that she's taken, it's just part of her disability that she's going to struggle financially this way. And so what a special needs trust does is it allows us to leave our estate in equal shares to our children. And it allows us to leave her portion in what's called a special needs trust. So the special needs trust, number one, will establish that there's someone that we have appointed as her trustee for the duration of her life. So it allows us to predetermine who will be managing her money, who will be in charge of kind of making those decisions on her behalf long term. And it also allows us to shield what assets are in her name, so that if she needs to qualify for government benefits, it will make her eligible. So she could have a special needs trust with $1 million sitting in it and still be eligible for government benefits. And the reason that this is so important is because so many of our children, when they reach the age of 26, they're no longer on our insurance. If my daughter with her autism cannot maintain a full-time job, she won't have medical insurance. She won't have reliable medical insurance that will ensure that she's getting treatment and care that she needs, and the medication that she needs to have as well. So by allowing her to apply for and qualify for government benefits, we know she'll have that steady insurance that will enable her to get the medication that she needs and the treatment that she needs with the doctors that she needs as well. While at the same time, there's a pool of money over there that can help aid her outside of what SSI pays for, which is housing and food. So a special needs trust is more than just protecting assets so that the individual can qualify for government benefits. It ensures that for her entire life, there is somebody who's going to be managing her finances for her in the event of our death. And for any parent out there who's watching this right now who has a loved one with any kind of disability, you know how important that is. So there are different types of special needs trusts. The first one that's listed here is what's called a third-party special needs trust. And all that means is that someone else's assets have gone into that trust, not the beneficiaries. It can be part of your will, it can be testamentary and only come to life once you've passed away, or it can be a standalone trust. I mentioned a little while ago that I already have a special needs trust for my daughter. Obviously, I'm still alive. So it's a standalone trust. And all that means is it's a legal document that my husband and I signed. And once we signed it, it was valid. And we got an EIN number for it, which is like a social security number for the trust. And we took it to the investment place financial institution we wanted to make her investment in, and we set up that trust. So we can put money into that trust. Anytime a family member wants to gift to her, they can gift directly to that trust. Other family members can also make her trust a part of their estate plan as well if they want to leave something to her. And then, at her death, whatever funds are remaining in that trust will pass to the subsequent beneficiary that's listed in that document, which is our other two children. So that's a really great tool to have in place, that we know what that money that's being put into that trust is not only protection for her, it's going to be managed well, and whatever money's remaining will pass to our other two children. It makes it a very flexible and useful tool, not only for our estate plan, but for our financial planning as well. The second trust that's listed is what's called a first-party Medicaid payback trust. These are trusts that are set up for individuals who are under the age of 65, who are disabled, and the trust itself can be established by a parent, grandparent, legal guardian, or a court. It is established with the funds of the beneficiary. So this is different than what I just spoke about, which are the third-party trusts, which is funds by the grantor. This first-party trust is typically, we see a lot of these, either one, if someone under the age of 65 has been in some kind of an accident or has had a medical situation arise which has left them disabled, and their funds need to be protected. So they can be protected and put into this type of trust. It can be established by a court in a settlement case where maybe there's a med malpractice lawsuit or a car accident, and there's a settlement from that lawsuit. It can go into this type of trust, which again will provide for that beneficiary during his or her life. And what's different about this trust is that it's not going to go on when that beneficiary dies. It's not going to pass on to other family members. What's left in that trust will go to pay back Medicaid. So whatever Medicaid has paid on that individual during their lifetime, Medicaid can lien that trust, and they will be paid back what they spent on that individual during their lifetime. The third special needs trust is what's called as a pooled income trust, and that is for individuals who are over the age of 65 who are disabled and need their funds protected. And those trusts are funded through the Alabama Family Trust, and it's a pooled trust, but it is also just a standard special needs trust, but is also a Medicaid payback trust. So you may think, well, I don't have a special needs child or special needs family member, and that's fine. There are other testamentary trusts that are very useful tools. One, which is a marital trust. A marital trust can be used in a situation where you have blended families. Blended families are so much more common these days, where you have second and third marriages, but you have children from perhaps a first marriage or another relationship. What this trust can do, it's called a marital trust, is let's say, for example, my husband and I have a marital trust. What it would mean is at my passing, my husband would inherit that portion of our estate, and it would be put into trust. Now, he could be the trustee, and he could use the funds from that trust for his life. But what it would do is it would protect those assets to ensure that at his passing, what's in that trust will pass to our children in equal shares, as opposed to if he were to remarry, then that individual could then inherit those funds. It ensures in a blended family situation that if the spouse were to remarry, that the second spouse would not inherit what should go to your children or what you would want to go to your children. And so this is a very useful tool for blended families. It is also a useful tool if you have a spouse who's disabled. You can do what's called a marital special needs trust. So it's a blend between those special needs trusts I just spoke about and a marital trust. And that is that you can, let's say my husband and I are married and my husband has a disability. I can set up in my will a marital special needs trust, which would say at my passing, anything my husband inherited from my estate would be put into a special needs trust. And why that's important is, one, it ensures that someone else is managing that money if he is disabled. And two, it ensures that if he is receiving government benefits, that one, he won't be kicked out of those benefits, or two, if he's applying, he won't be denied benefits just because of my passing. Another useful tool that we see very, very common, and it's something we see very often, is pet trusts. We all love our animals. This was just talking to the folks at UAB about some of my dogs. Alabama does allow for the creation of pet trusts, and they are a valuable resource if you want to leave pets to a friend or a family member and just want to make sure that you've provided those resources to ensure that your pet's being taken care of. You know, a lot of times we talk to family, we talk to couples or individuals who just say, I want to leave my pets with so-and-so, but I don't want them to be financially burdened with the expenses of my pet. And so we set up this trust to help care for and take care of those pets. Another option for trusts are gun trusts. You may think, well, that's odd, but there is a way to set up a trust for guns. There are special rules and provisions that have to be followed to ensure that the NFA rules are not violated. And so we're seeing more and more of these trusts or people requesting these types of trusts. Charitable trusts are also a valuable tool. It allows you to support specific causes and create lifetime income opportunities. And it also allows you to avoid taxes. These types of trusts can have a very meaningful impact on charity, while at the same time providing a real tax benefit to your beneficiaries as well. There's also life insurance trusts, which can be established with a life insurance policy. Again, this is a tax, it allows your estate to kind of be exempt from certain taxes in your estate. There are lots of other kinds of trusts. You know, I spoke earlier about it. If you have a family member who may have addiction or may have just a really hard time managing money, or you have children who, adult children, and I use the phrase children, I mean even adult children. If you have children, minor children or adult children who have a difficult time managing money, a protection lifetime trust is a wonderful tool to ensure that that the funds are going to be protected, they're going to be used for that individual, that they'll be invested properly. But in summary, trusts are very useful and economical planning tools. As I spoke earlier, conservatorships can be very expensive, and a great way to avoid conservatorship, not only for minor children, but for adult disabled individuals, would be to have trusts in place. They are not reserved for the ultra wealthy. Even if you're leaving your children a few $1,000s, but you're afraid they'll use it to further their addiction or their habit, and you want to make sure they're protected. Again, this is a really useful tool. If you have a special needs child who may be on benefits, you may think my child will never be on benefits, they'll never qualify, or they won't need it. The truth is they may. You know, when they graduate high school, if they can't go on to college or keep a job, there may be options for them to be on the Medicaid waiver program, where they can go to day programs or receive other types of services and support programs that if their assets aren't shielded, they may not qualify for. Again, they are useful tools for blended families, where one spouse wants to preserve the inheritance for his or her children. They're wonderful for families with minor children. They're wonderful tools for aging or disabled parents, for families with a disabled family member, for individuals who need their inheritance to be protected for any reason, for the care and maintenance of our pets, for charitable giving, and for individuals with property in multiple states, and for many other reasons. You know, if you're hearing this today and you're thinking you're in that 52% who's just getting started in your estate plan, it's wonderful to come talk to one of us here at Carney Dye to just say, hey, you know, I heard Jenny talk about trust, and I have this pet, but I also have, you know, X, Y, and Z family members that I want to ensure inherit something from me, but I want it to be protected. We can do all of that for you. You know, what I always say is, you know, make sure that when you do your estate plan that you're doing it with someone who knows all about trust and how they can be used, and that you're using it properly. Another thing to keep in mind, you may say, the 22% who answered the poll earlier and said, you know, my estate's already set. The truth is, as we tell our clients, you should be updating your estate plan every 5 to 7 years. You may think that that's quite often, but the truth is a lot can change in our lives in 5 to 7 years. You may have agents appointed in your documents who've passed away or are incapacitated and can no longer serve as your agent. And you can just update those documents and make sure that they're up to date, that you have everyone in place that you want in place, that you make sure that the needs of your children are reflected in their distributions in your estate. The laws may change during those 5 to 7 years. A new administration's in place, so the taxable estate may have changed, the limit may have changed. So you may need to go back and talk to your estate planner to see if there's a better way to protect your estate. And, part of your estate, when we talk about your estate, is a durable power of attorney and a healthcare directive that we recommend you always keep up to date because they're more readily accepted the closer in time that they have been executed. So that's pretty much it for me in my presentation. I believe now we're going to open up for questions. I've put here just my email address, our telephone number.
Once she's done with this and we go to questions.
And then our website, where if you want to look more at what our firm does and who we are, you can find information at our website at carneydye.com. But yeah, we can go ahead and I believe turn it back over to Greg and see if he has any questions from you guys.
Yeah, we got a lot of questions, and sorry about that. I was communicating with somebody on the back end to tell her to drop those slides so we can get these up, and that's one of those technical glitches that you just kind of get. So let's go ahead and start with the questions. Does trust law from the grantor or beneficiary state apply?
I'm sorry, I didn't catch that. And I can read, but if you can say it one more time for me. Yeah,
it is. Does trust law from the grantor or beneficiary's state apply?
So it's usually where the individual, where the trust was established. The document itself is usually pretty explicit about what has to be done and what can be done. Now, we do a lot of trust administration. We manage a lot of trust disputes if trusts aren't being managed properly, if they're being abused. We handle that type of trust administration as well. So if you have a question about the administration of a trust, I would always say first look at the trust document itself. And then second, if there's a conflict in law between where the document was established and where the beneficiary lies, consult a estate planning expert in the state where the beneficiary is.
Okay. So this person lives in Florida. Is a trust or probate the best way for them? They are 69 years old.
So in Florida, we typically say living trusts are very practical tools because probate can be very costly and burdensome in Florida. So we typically recommend you do get a trust in Florida. Now, again, I recommend you consult an expert in Florida. I'm not licensed in the state of Florida, so I'll make that disclaimer as well. But historically, living trusts are more popular in Florida and California to avoid probate.
How hard is it to dissolve an irrevocable trust when it has a zero balance? All debts are paid, taxes are filed, and disbursements are made to the beneficiaries.
It's not hard. We can do a trust termination agreement for you, and with the beneficiary signing on, we can terminate that trust.
Does a testamentary trust for your child or children also shield those assets from creditors, judgments, etc.?
Yes, it does. So if you have the right type of trust set up. So we do this a lot with some of our clients who have adult children who have a lot of debts and who have a lot of creditors, and the parents don't want their inheritance to come subject to all of those creditors. And what we do in that case is we set up one of those protection trusts that I spoke about, and we have a sibling service, the trustee. And what that does is it shields those assets not only from creditors, but it also shields it in the event of a divorce. So if you're concerned about your child inheriting from you, and you think that maybe they'll go through a divorce and you don't want their inheritance to be part of that divorce, you can also use a trust for that purpose as well.
What if a trustee dies before the beneficiary, or even a contingent trustee dies before?
So typically we recommend that you put in multiple trustees so that if one does die or is unable to serve, there's an extra layer of protection in a trust, where you have maybe another individual who can serve solely for the purpose of replacing or renaming a trustee in the event of a conflict, of incapacity or death.
So for special needs trusts, can you have one executor for financials and appoint a different person for medical directives?
Yes.
Okay. What are tax rules for, what are the tax rules for trust?
So trusts are taxed. They are taxed at a lower bracket than you are individually. They have their own tax bracket. So you do need to keep that in mind when you're thinking about setting up a trust. Again, that's one of the functions of your trustee, is to ensure that those taxes are being paid each year and that returns are being filed.
So what kind of special tax liabilities or will this person's beneficiaries have if they are not U.S. citizens?
Oh, well, that I'd have to look into, and it would be probably specific on where they're located.
Okay. This person is a legal resident of Hawaii, but they have real estate in the state of California. Where should they file for the will and trust?
So if you live in Hawaii and you have property in California, I would recommend you speak with an attorney who's licensed in Hawaii, but you probably want to look at setting up a revocable trust. And with that revocable trust, you can title your property in California with the trust, which would allow you to avoid, at your death, from there having to be an estate opened in both California and Hawaii. Does that make sense?
It does. So why would life insurance trusts be necessary when benefits are not taxable?
So the life insurance trusts are, we see those with our kind of higher end, wealthier individuals, and those trusts are used to pay the taxes on the estate a lot of the times. But yes, typically for your average family that's coming in the door, life insurance policies pass outside of an estate because they're paying pursuant to the terms of your contract, which is whoever you've named as your beneficiary is how it would be paid, and it doesn't have to pass through your estate. But there is a planning technique that it can be utilized for the purposes of paying taxes.
How easily can a trustee break the trust for the purpose of using the assets in a manner contrary to the trust?
It's something that can be done, but it's something that they would be held responsible and accountable for. It would be a breach of fiduciary duty, and that individual would probably need to go speak to someone who specializes in that area of the law to look at how they could get court intervention to remedy that breach.
What states are you licensed in? What states can you advise people in? Is it just Alabama?
So I'm licensed in Alabama and Mississippi.
Okay.
Titled as the trust, that trust holds it and controls it.
Okay. These last two questions are very similar if we don't get any more, and feel free for our people that are watching, go ahead and continue to ask these questions. So the twofold is, what are the pros and cons of establishing a special needs trust while parents are still living?
Yes. So the benefits of, so the benefit is that, one, you can go ahead and fund it and use it for maybe medical needs or things that individual needs during their life. Two, other families can use that trust in their estate plan. Another viable tool that I didn't mention that I thought about adding a slide on, but I took it out, for our special needs community is what's called ABLE accounts. And if you don't know what an ABLE account is, it's a truly wonderful tool. It's a 529 account. It was created, I think about 7-8 years ago. And it's a 529 account that's not just for educational purposes, but can use for any qualified expenses, which, I mean, the list is exhaustive. It's transportation, housing, food, medical needs. There are more restrictions and limits on an ABLE account, but I am a huge proponent of ABLE accounts. And I think anyone who has a family member or friend with a disability who had their disability before the age of 26, I tell them, go set up an ABLE account. If you have $50, set up the Enable account today. You can do it online. They kind of shield and protect assets the same way a special needs trust does, but they're a little more restrictive, and there are some drawbacks and pros and cons to those accounts as well. So I always tell parents, if you're unsure about doing a standalone special needs trust and you think, I don't have money to fund it, my family doesn't have money to fund it during our lifetime, always tell them, go set up an ABLE account, do that today, and put a special needs trust in your estate plan, in your will. Make a testamentary special needs trust if that's all you feel comfortable doing. But you can you can execute a standalone special needs trust and not immediately fund it. You don't have to immediately fund it. You can hold on to it until you're ready to fund it as well.
What's the main difference between a will and a trust, and do you need both?
So a will is a document that tells a court how you want your estate or things that are titled, things that you own in your name to kind of pass at your death. A trust tells your trustee how you want your assets to be managed and given to your beneficiaries.
Okay. So this person, they just want to clarify, did they understand correctly that the tax rate is lower?
I would love to talk to this individual if they have questions. There are tons of articles online as well. I think it's ablenow.gov. You can find information about how you can use special needs trust and an ABLE account in tandem. You can use your ABLE account to manage kind of your month-to-month expenses and use your special needs trust for more of your long-term financial goals for those individuals. Your special needs trust can inherit. An ABLE account cannot. So you can name a special needs trust and a life insurance policy in your will. You cannot name a special needs. You cannot name the ABLE account. So as a planning tool, the special needs trust is the best option, but day-to-day living for an individual with a disability, I recommend an ABLE account.
Okay. So what type of trust is it if you're just protecting your assets?
It depends why you're protecting your assets. If you're protecting your assets for purposes of trying to qualify for Medicaid, it would be an irrevocable trust. If you're looking at a way to protect assets of your children who have creditors or may get divorced, that would be your protection trust. If you have a spouse that you want to protect assets for their lifetime to ensure they go to your children instead of a future new spouse, that would be that marital trust. So it really determines how you want to protect your assets of how that trust gets structured.
What does probate involve?
Right, so probate is in your estate plan, you will name what's called a personal representative. It's the person that you have appointed to kind of collect your assets, collect your debts, and ensure that your wish. And then the estate stays open for about 6 months while potential creditors of the estate can come forward. So let's say medical bills, any kind of debts of that individual can be filed with the court. At the end of that 6-month period, if there are any creditor claims, they can be negotiated or paid. And then what's remaining in the estate as an asset will then be distributed to the beneficiaries as stated in the document.
So this person has a blended family, and this will be the last question before we wind things down. What advice can you provide for them to ensure that both children are covered? Should they go will or trust?
You would do your will, but part of your will would be a marital trust. So those documents, when we talk about them, they're not always separate things. They can be together. So part of the will would have built into it a marital trust. And what that would do is it would say, at my death, everything goes into this marital trust to provide for my spouse so they can use it for their health, maintenance, for the duration of their life. But when they die, goes to my children. That ensures if they remarry, it won't be subject, that individual won't inherit at their death.
So one last time, I know it was on the ending slide that you had, but people may want to get in touch with you. Give us that email and other contact information.
Yes, so my email is jennifer@carneydye.com, and our website is carneydye.com. And our phone number is 205-802-0696.
And I will go ahead and drop those bits of information in the email for everybody that attended today. So you should be getting that tomorrow. I'll make sure that's in there. So Jennifer, thank you so much for this very insightful webinar. It's been great information. Just a heads up to everybody that did attend, today's webinar will be available online tomorrow. So a lot of people are asking, can they get copies of the slides? You can view the webinar as many times as you want. The slides will be right there. So now, with more information about the UAB Office of Planned Giving and how they can help you, I would like to turn things over to Kimberly Kopic once again. Kimberly.
Great. Thank you, Greg. And thank you, Jennifer, for all of that information you shared with us. Again, my name is Kimberly Kopic, and I'm the Senior Director of Planned Giving for the UAB Office. A planned gift can help you make a powerful and lasting legacy to the UAB programs that mean the most to you. Planned gifts offer creative, flexible strategies for your estate and charitable planning. These techniques make use of legal and tax strategies to best suit your unique situation and help you accomplish your personal and philanthropic goals. There are many types of planned gifts. Some types allow you to maintain control and flexibility over your assets while supporting UAB in the future. Others allow you to obtain an annual income and an immediate tax deduction. Still others allow you to reduce or eliminate capital gains tax. The UAB Office of Planned Giving is here to help you accomplish your philanthropic goals through a legacy gift. Reach out to me today to learn more about these types of gifts and to find out how they may be a good fit for you or for a loved one. Thank you.
Thanks so much, Kimberly. Be sure to join us for other virtual events coming up. On April 6th, we will be exploring UAB's Oral History Collection. This webinar will take a look at the history of Alabama, Birmingham, and UAB. Then on April 22nd, join us for What's the Latest Science Say About Living Longer, Healthier Lives, as we dig deep into geroscience and find out how it studies the biology of aging. And on May 20th, be part of the Arts as a Tool for Healing and Wellness, as we welcome Elizabeth Vanderkamp and Kimberly Kirkland from the UAB Institute for Arts in Medicine. You can register or find out more about all of these at alumni.uab.edu/events. Looking for alumni podcasts? Check out the UAB Green and Told podcast. Episodes drop every other week and feature members of the UAB community. You can find the podcast on Spotify and Apple Podcasts, or just visit alumni.uab.edu/green and told. And don't miss out on our 15th annual scholarship run presented by Viva Health. It is virtual this year, and it will be held April 23rd through 26th. Registration is only $35. You can register at alumni.uab.edu/run. And be sure to stay on top of all things alumni on social media. We are UAB Alumni on Facebook, Instagram, and Twitter. You can look us up on LinkedIn by searching UAB Alumni Career Community. And if you want more information about the National Alumni Society, visit us at alumni.uab.edu or just email alumni@uab.edu. Once again, thank you so much for joining us for today's discussion with Jennifer McInerney. Everybody have a great afternoon, and as always, go Blazers.